When a prosecutor seeks indictment from a grand jury while also interacting with the judge, they should act both as an advocate for the state, presenting evidence and legal arguments to the grand jury, and as an officer of the court, providing information and adhering to legal procedures in their interactions with the judge. The prosecutor presents evidence to the grand jury, including witness testimony and documents to establish probable cause for an indictment. Okay, so that's cool. After reviewing evidence and determining that probable cause exists, the prosecutor can request a summons from a judge instead of an arrest warrant, especially if the individual is unlikely to flee or pose a danger. And he was issued a summons, so by definition, he is unlikely to flee and does not pose a danger. So why at his arraignment was she asking for $25,000 and telling the judge that he was causing or would have caused harm to the alleged victim / this community? It doesn't make sense. Then it says direct indictment right after that, or like a couple days later or whatever. So why would you need to convene a grand jury at all if you can summon somebody and then just call for a direct indictment and just assume that there's, or just declare that there's probable cause on both? Well, what's the point of a grand jury?
You are ordered to report for fingerprinting and photograph on the 7th floor. You can do that before your first case management, or you can do that today.
7th floor?
7th floor. Does the state wish to be heard regarding the release?
Yes, Your Honor. Your Honor, the state is asking for a $25,000 bond and pretrial services release if that is posted. We're also asking for numerous conditions of any release. And I'm going to go through under Rule 7.2 of the Arizona rules that the release conditions, somebody is to be released on recognizance unless the court determines additional conditions are reasonably necessary to assure the defendant's appearance or to protect the victim, any other person, or the community from risk of harm by the defendant. And so we are asking for additional conditions. In this case, we're asking for no contact with the victim to protect her from physical harm, harassment, intimidation, or abuse. The court can also order additional conditions, including to protect another person or the community from risk of harm from the defendant. We believe that a non-monetary condition is not sufficient, so we're also asking for the monetary condition of the $25,000 bond. That's both for the reason that Mr. Myers is facing mandatory prison time if he's convicted of these offenses. He does have prior felony convictions that, while older, will make him prison mandatory. Even on the first felony offense and each subsequent felony offense, he faces mandatory prison time. These are also offenses that can be stacked, so he's facing a large amount of time. Also, he has had an injunction against harassment on him already, and so he's been court-ordered not to have contact with this victim. Yet, in spite of that, he has continued to have contact with her, reach out to her, ask for third parties to reach out to her. He has been posting about this case. He has been bringing attention to her, which has been subjecting her to harassment and intimidation. Mr. Myers himself, even after receiving the summons in this case, reached out again through an email he sent to the victim in this case. He again was on.
I can't keep listening to that. That is so fucking wrong what she does. Anyways, so yeah, that's the thing. She got him there under summons, which is like for non-violent people who show up to court and want to take care of their shit, and then just lies her ass off to get a bond, or so they can release him, right? So they can release him and then vaguely tell him the conditions, like we heard, and vaguely tell him the conditions of bond. So he breaks them and then charge him with a felony. It doesn't matter what it is at this point, because that's all they want to do is be able to let him out and then recharge him. This is what they do to people on probation all the time. Like, this happens to people all the time, but it's normally they got caught with drugs, or they actually have some kind of sustenance to their illegal activities, and nothing like making YouTube videos.
online talking about this case, drawing attention on that post. That the posting was done by a third party, but he did participate in that post and was on that post. In that post, it posted again the victim's email address. It was asking for people to reach out to her. Her husband is also subject to that. And so we are asking for these release conditions of not just non-monetary conditions, but monetary. As far as the non-monetary conditions, we are asking for him to not possess any firearms. In the post recently, he talked about wanting to get a firearm. Given the safety risk in this case, we are concerned if he were to get a firearm. We're asking again for the no contact with the victim. We're asking for no contact with the victim's family.
A direct indictment is a legal process where a case goes directly to trial without a preliminary hearing or preliminary inquiry, which is a process to determine if there's enough evidence to proceed with a trial. This means that the accused bypasses the usual steps of a preliminary hearing where a judge decides if there's enough evidence for the case to proceed to trial. Direct indictment is typically used in situations where the prosecution believes there is strong enough evidence and/or specific circumstances that warrant bypassing the preliminary hearing. So it's where a prosecutor bypasses the grand jury and directly files charges with the court, which then can proceed to trial. So the defendant loses the opportunity for a preliminary hearing where this is the hearing where the judge would determine if there's probable cause to proceed to trial. So Rachel is just saying there's probable cause and nobody else is going to do anything about it. So why does this grand jury shit keep coming up in the filings? It keeps saying indictment, but here it says an indictment is a formal accusation issued by a grand jury, while a charging document, like an information, is a document filed directly by the prosecutor. Well, it says direct indictment. So now what she has to do to cover her ass is pretend to convene a grand jury or supervene a grand jury so they can turn down the whatever request, and then she can ask for a summons or a subpoena to cover her ass, because what she did is deliver the indictment / information / complaint to Mr. Myers as a summons. Now she has to cover her ass because of that, and that's why this document exists that says it was improper or not appropriate for her to ask for one. On Friday, March 28, 2025, the state stated that the defendant was indicted on direct indictment and requested a summons with booking. This was not appropriate as the defendant was in custody and being held without bond. The state asks that a notice of supervening indictment returnable by Friday, April 4th, 1 p.m. You see what I mean? Why would you need to supervene a grand jury and have them decide that there's probable cause and get an indictment if your person is already in custody and held without bond? They're not going anywhere. She needs it so they can issue a subpoena with that, so she can have the summons that she didn't have in the beginning when she used her indictment / information / complaint to get him there in the first place. You know what I'm saying? So to recap, what she did was she gave Mr. Myers, or used that document, the information, complaint, indictment, to give to him as a summons. And then when he got summoned, she used the supervening of the grand jury to ask the court for the subpoena or the summons, which she should have originally gave him. As we see here, she just put the bold word summons on there for the complaint, indictment, information. So never heard of a complaint, indictment, information summons. Hilarious. And no problem getting it authenticated because she has the stamp to use at her discretion. So no problem there. Got all her bases covered. Too bad, bitch, I got you. And then boom, do her direct indictment instead of using the grand jury, because the grand jury would never indict him. So anyways, that's what I think. And you might be thinking to yourself, well, why go through the whole thing of doing it that way when it doesn't even matter because you're the prosecutor and blah, blah, blah. Well, because doing it that way is a crime. Doing it the way she did it is a crime. And if for some reason I'm reading this wrong, then it really doesn't matter because it's only a misdemeanor if it's done before the person is in custody and Lane has been in jail for 38 days, so it doesn't matter. But what it does do is tell me for sure that an information indictment complaint is separate from a summons. It's not all one document. And here's how this bitch is authenticating documents that she's receiving in the future and putting them back in the past officially. Self-authenticating. Notice the date, April 2nd, 25, right? And she said everything's self-authenticating because it's officially stamped, right? Gary Harrison, this guy, according to Supreme Court Rule 93 and the Arizona Supreme Court Administrative Order or 2000 whatever, provide that the presiding judge of each county administrative supervision responsibilities over the clerk, blah blah blah. Whereas incumbent clerk superior of the court Gary Harrison has retired midterm, and whereas Mr. Harrison's effective date of retirement is March 31st, 2025. March 31st, right? And on the 31st, 2025, the governor of Arizona appointed James W. Garasimo as clerk of the Superior Court effective April 1st, 2025. But there must be a continuation of the operation of the business of the clerk of the Superior Court in the county. So it's ordered that the file stamps, signature stamps, certification stamps, signatory authority, and the official documents bearing the Gary Harrison name shall continue as the office name of the clerk of the Superior Court in Pima County until modified by clerk of the Superior Court appointed James Garasimo or whatever. Basically, she's just using the old stamp. I mean, whenever she wants, dude. She can just, this is bullshit. So, long story short, she shouldn't be authenticating things with stamps at this stamp after the 31st. April 1st, it should have been over, and then she has two, April 1st and one April 2nd. Come on. For a document that could have been stamped on the 28th or the 29th or the 30th, but she waited until the 1st so she could use the old one at her discretion. Wow.
And they're concerned that they're going to be posted on the internet and have a lot of people coming after them.
Targeting them, concerned that they are going to be posted on the internet and have a lot of people coming after them. I mean, is she just trying to make it seem like there's a lot of people? Because there's only one victim. There's only one. Why is she saying there's multiple people that he is going after and multiple whatever, you know what I mean? And even the one victim is not a victim. Even her saying that is malicious or stupid. I don't know. It's malicious or stupid. You tell me.
Like I said, he has targeted everybody involved.
There again is everybody. Who's everybody? It's just only one person. Is she being stupid or is it malicious? It's either malicious or stupid because she's wrong.
His criminal cases, including posting addresses of theirs online. And
again, one person's address, and it was a work address. And why does she keep saying them or those people or whatever? Is she being malicious or stupid?
For 6 under 133967B is 6 weight of the evidence of the accused. The state has very strong evidence of all of his crimes in this case. He's been live streaming about them, so we have video evidence.
What was that ARS again? 13 what?
Under 133967B is 6 weight of
So he was released and then revoked because he committed a new crime. Well, his new crime is the same as the first one, which is in dispute, and he's innocent until proven guilty. So how can a showing of probable cause that he committed a new offense whenever she's the one that found the probable cause in the first place? This is ridiculous. She can't play every role. There's no witnesses. There's barely an alleged victim, and everything the alleged victim had or got, she emailed it to the cop, and then that's the evidence, and it's the police report and the evidence, and it came all from the victim, the alleged victim, Shannon Walker, and her husband, Matt Walker, half and half, and all it is emails and then Mr. Myers' videos. That's it. There's nothing else. and then used for the information indictment complaint. And it looks like it's copy and pasted word for word almost, and date for date. Now that they got him straight, and now that Rachel is...
We have his admissions. Just yesterday, he went on and went through every single charge, talking about what he did to commit those offenses. So the state has very strong evidence against him, and we also have the records from the court. And then as well, the accused record of arrests and convictions, as previously noted, he does have prior convictions, which makes him facing mandatory prison time, and he has a lengthy arrest history. And so, for all those reasons, we are asking for these more stringent release conditions, because I think it's necessary to protect the victim.
To protect the victim? I mean, obviously, she's not a victim because, again, he hasn't been convicted of a crime. So, but why is it back to one now instead of what? She doesn't want to protect all of them?
And others in the community and other people connected with this case.
So she needs to protect the community from this crazy animal, but she used a document that is to only summon the gentlest of criminals to the court. This is absolutely ridiculous.
And just from him getting a summons, he immediately targeted again the victim and immediately
Targeted the victim. Again, she's not a victim, and targeted the alleged victim. Only one? I thought there was many of them. What if he was targeting her with a $100 million check and an apology note? What is she targeting? What is he targeting with?
He was calling upon third parties to engage in harassment, intimidation, and abuse towards this victim. And so these release conditions are necessary to protect the integrity.
There, she just said it. These release conditions have nothing to do with him harming or hurting anybody. They have to do with the integrity of whatever, the investigation. She's only making these conditions for a show. She should just doing it. It's a show. She has to show that he is dangerous in some way to protect the integrity of all those 14 charges that she put on him that are ridiculous and bogus. Is she stupid or is she being malicious? I think it's malicious.
To protect the integrity of this case, to protect the integrity of this system, to allow people to maintain confidence in the judiciary system, and above all, to protect the safety of our victim.
To protect the safety of our victim. Why is she using the word O-U-R, our victim, or our victim, whatever? It's the alleged victim. It's not a victim, and it's not yours. It's not possessive. You can't possess. This lady is absolutely malicious and stupid. She's both. It's malicious and stupid is what she is. Well, look who is fucking right. So this is how far I was in making this video whenever this came up today, and I screen recorded the part that perfectly proves what I've been saying about this dumb bitch. She understands the idea of a word triggering legal action. Like, for example, the word victim. Like I've been saying, it triggers something in the law that she gets to use to her advantage during this whole trial. And the judge just acknowledged that he understands that. She said it out loud. She understands that. And they're still overlooking it. It's fucking, this is crazy.
Who can't be there.
They testify against me.
So I want to clarify, it's not his wife. They're not actually legally married. And
Time out. No. You got to stop. What we call.
So
hold on,
there-
hold on, Mr. Myers, just
No, I'm standing on business with this. They need to stop telling me what I call my wife.
Mr. Myers,
If we
hold on.
No, they don't. They keep putting this in motions and putting it in quotes and all this.
Hold on. Just let me talk. So,
It's disrespectful.
Hold on. No, what they're saying is there's a privilege between spouses.
We know what that is.
Okay. But you can only
We're
claim
not
that
exercising it.
hold on.
Nobody's exercising that. Nobody.
That's what she's mentioning.
No, but
for.
they're putting it in motions too. Stop disparaging our relationship.
No one's disparaging it.
They put it in quotes like, "Oh, he claims it's his wife." What do you think? I'm secretly claiming my wife and she doesn't know it?
Hold on. It's only as to whether the privilege applies. That's what
Nobody brought that up.
Okay, that's why she's
They brought
doing
it up in motions.
All right, Mr. Myers.
His wife. They brought it up in a disclosure thing.
All right. I understand,
his
Mr. Myers.
wife, but they're not married. We can be in a relation. You don't have to be legally married so that that's to protect assets.
It's only to talk
Legal
about the
reasons.
privilege.
No, it's not. It's to be rude and
No,
disparaging.
they're not being rude. They're not.
Okay, well, I'm going to call her the fake victim then.
No, we're not going to do that. That's disrespectful too.
Well, I mean, she's not really a victim.
Mr. Myers.
It's like she's not really my wife, right?
Remember, I allow you to hold on. Hold on.
They're picking at this. They've been doing this over and over, though.
Mr. Myers, I allow you to represent yourself if you're respectful. Okay, that's a rule.
All right,
and I had the chance to pull that.
Okay.
The only reason she mentioned that was as a privilege, and we're not talking about that today. So, okay.
And
just to clarify, if you meant it that way, you would have opened with, well, the legal side of the whole wife thing is, and then explained it. You wouldn't have just said it like snap-backed it like you did, and then try to have the judge cover for you, you dumb bitch.
That is the reason I'm bringing it up, because when in a legal proceeding, if you refer to somebody as a wife, that triggers certain legal things. And so that's why I'm clarifying that for the court.
Right.
And
no, Rachel, what you've done is prove me right. Prove that you know that certain words trigger certain legal issues, like the word victim, right? You just admitted that you know what you're doing is malicious, you dumb bitch. Oh, and that I've been right for like 2 weeks. Thanks. And I'm about to explain it to everybody that's watching this, and I hope your dumbass bitch ass watches this, Rachel, you stupid piece of shit, human trash can, you stinky, ugly fucking girl. Okay, let me explain. The Victims' Bill of Rights, the Arizona Constitution 2.1. This is why I've been so mad about her throwing around this word victim, because look at all these things that word victim triggers. Look, you can be heard at any proceeding involving the post-arrest release decision and negotiated plea and sentencing. You can refuse an interview, deposition, or any other discovery request by the defendant's attorney, or other person acting on behalf of them. You can read the pre-sentence reports relating to the crime against the victim when they are available to the defendant, to receive prompt restitution for the person, blah, 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 to be heard at any proceeding or any post-conviction release from confinement that is being heard, be informed upon request that the person who's convicted is released from custody or has escaped, to be present at, I already said that. I think the best one in this case, because Shannon's a fake victim and probably should keep her mouth shut, is that she can refuse any deposition and isn't going to be held responsible for any lies she tells to the cops, because that's part of it too. And this one's going to blow your mind right out of your butthole. It's called absolute privilege, and this is what crime victims get. It is a privilege that is in defamation law, provides complete immunity from liability, even if a statement is false and made with malice. In certain contexts, it is a complete defense to defamation claims. The privilege applies to specific situations, primarily those involving judicial or legislative proceedings and related acts of the state. Basically, you can lie to a cop and not get in trouble. And yes, calling a person a victim triggers all those things. Now, she's a fake victim, but what about real victims, right? Or what about people who want to be victims? Like, who are the biggest pussies in the world that are not supposed to be the biggest pussies in the world? Cops, right? And who has the power to charge you with a crime that would fit, like, that's why they have that DV checkbox, the domestic violence. Disorderly conduct is a domestic violence crime. Now, so what if a cop just charges you with domestic violence and then puts you in jail, and that's a domestic violence crime? Now he can legally be a victim, and that's what they do. And this would be the box that they check, victim notification. So this cop that arrested Lane for disorderly conduct, or that was standing there next to him or whatever, now gets a notification every time he's released from jail, or he goes to jail, or he has any kind of proceeding or whatever, then he's going to get notice of it. Crazy, right? And they do this all the time. And they also use this is the reason you can't depose any of these fuckers, is because they have the clause in the Constitution, the Bill of Rights of Arizona, where you can refuse that shit. And it's not just people that can claim to be victims, it's whole entities. Like the Pima County Legal Services is a victim of Lane. Anyway, moving on to some more dumb motherfuckers that just abuse the shit out of their power and their positions. And yeah.
Okay, this is case C-2024-6055. The plaintiff is Shannon Walker and the defendant is Lane Myers. Ms. Walker, this is a time and place set to hear an injunction against harassment. Ms. Walker, could you please stand and raise your right hand? My clerk's going to swear you in.
Do you solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, she's sworn in.
So, thank you. First off, can you state your first and last name for the record and spell them, please?
Shannon Walker, ShannonWalker.
Okay. So, Ms. Walker, I'm going to be asking you some questions about the allegations that you've made in your petition here.
Okay.
I'm also going to ask you some questions about guns. Now, I don't want you to think that I have some super secret information back here. I have no information at all regarding the defendant or anything. These are statutorily required. And so if I ask you a question, don't think I know something because I don't.
Understood.
I've only got what you've given me here in front of us. So, and I've read through the allegations here and I'm a little confused. What is going on?
So I work at the College of Law. My spouse, who is with me, Matt Walker, is a prosecutor for the city of Tucson. Mr. Myers is a...
And she introduced her spouse. Okay, no big deal. Just letting everybody know who's there. That's good.
Claims that I am a public official, that anyone can come talk to me and I have to see them, I have to speak to them. So not only has he claimed that, he has told his followers that, and yesterday he actually said, I'm going to the College of Law. It was something that was very upsetting, not only for myself, but now my colleagues are in fear that this person is going to come over because we've had to connect the University of Arizona Police Department and our threat management team who has been following this gentleman.
She just said she has a police team following Lane.
So it's now not only affecting me, but my people I work with. And, you know, obviously we have our personal relationship. I don't have anything to do with
Did you hear that? So, our personal relationship. Why did she say that?
Then, you know, obviously we have our personal relationship. I don't have anything to do with this. So I don't know why this is even happening.
Well, I'm very sorry that is going on.
Not your fault, but I appreciate that.
Yes, it's difficult. So I am going to go ahead and grant the injunction against harassment. I do need to get some statements from you under oath. Now,
what do you mean under oath? We heard you swear her in at the beginning. What do you mean under oath, lady?
Obviously, to grant an injunction of harassment, there needs to be a series of events, and you have definitely listed be called. Ideally, they will understand that they're included in some way on this. I'm probably going to have to be told, but
yes,
get the general idea. So, based on the pleadings, the court finds reasonable cause to believe the defendant has harassed by committing one or more acts of harassment, and therefore it's ordered granting the injunction against harassment and orders that the defendant will have no contact with the plaintiff, with the protected persons listed in the injunction against harassment, or with the protected locations. The court further orders regarding this order of protection. A constable will not serve this for you. So it will go into effect when he is served, but you are going to need to personally have that served on him, either hire a process server, take it through the sheriff, whichever you feel. Obviously, you're not going to hand it to him yourself.
Right.
But, you know, it's important, and I'm not telling you anything you don't know. If he violates this, you must call the police. It is only as good as you are in enforcing it. And if you want this to truly protect you, be sure to take advantage. The court's not an enforcement mechanism. It's the police that will enforce this, but do not hesitate to call them if he violates this in any way. Okay?
One question that I do have is regarding the videos that currently exist, as well as additional videos, which I do think you are correct, this will likely incite more of a reaction, does this injunction against harassment provide any sort of protection for additional videos or any sort of enforcement for him to take down the current ones?
That would be up to a prosecutor. I'm really not sure how they would interpret that. I think the ones that are already posted, I think you're going to have a hard time getting those down, just because of the nature of the internet. I think, though, that if that is something that you should probably pursue with the prosecutor's office or through a police report if you want to try to do something with that. That would be my advice.
Okay, thank you.
I'm not sure how far this is going to get you from stopping those, but if you don't call the police and try, it's not going to get you anywhere.
Right. Okay. And I guess that's my primary concern is not just him, but the harassment that he is inciting through those. So.
And, you know, I think those could possibly be seen as third party contact, et cetera, et cetera. And I think that's going to depend on how the prosecutor's office wants to interpret that.
Understood. Thank you.
Okay. Do you have any more questions for me today? Is there anything else I can do for you today?
Sorry, I just want to ask a question. Can you just ask specifically about future videos if that's inconvenient?
Your Honor, does this order, injunction against harassment does it encompass any future videos?
It should, but again, it's going to be up to the interpretation of I mean, you know, especially if a video is like directed directly at you, I think it becomes a little questionable. If it's a generic, you know, that's really going to come down to interpretation.
Okay.
Does that help at all? I wish I could offer more than that.
No, we very much appreciate, Your Honor. Thank you. I think that's all.
We'll go ahead and we'll get this in place. You could go back to room 203. They'll get you all the information. It should be through to you shortly, okay?
Thank you very much.
I wish you the best, both of you.
Okay, so a couple principles of stupid here. All right, so the beginning when she introduced him, that's what she should have done. And then after that, he should have exited the room, or she should have stopped the hearing or whatever, because that is a conflict of interest. You need to announce and put on the record what exactly and who exactly it is that has a conflict, and then they need to immediately not participate in whatever it is that you're doing. That's a law. An ARS. It's not just a saying, conflict of interest. It's an actual law. 38503, conflict of interest. Any public officer or employee of a public agency who has or whose relative has a substantial interest in any contract, sale, purchase, or service to such public agency shall make known that interest in the official record of the public agency and shall refrain from voting upon or otherwise participating in any manner of an office or employee in such contract, sale, or purchase. This is a contract. Any public officer or employee who has or has a relative with a substantial interest in any decision of any public agency shall make known that such interest in the official record, and such public agency shall refrain from participating in any manner of an employee or a officer in such decision. And now, what about this bullshit she said right here?
Then, you know, obviously we have our personal relationship. I don't have anything to do with this. So.
See, I think the whole officer accidentally saying the ex-girlfriend thing was supposed to happen at this time, October 10th-ish, you know what I mean? And so whenever they planned his arrest on the 22nd or whatever it was, that this would be the police report that was released, because that's when it happened in summertime in October. And then that this would come out because they knew he would publish this, because he does it with everything. And then they would have put those two and two together and said, oh, it's because he published this. He published the recording of her, and you know what I mean? And then the police report, and then that's how we know, you know what I mean? And now for the stupidity of Matthew Walker. How dumb is that fucking comment about future videos? Only somebody that stupid would repeat that after saying it out loud and not hearing how it sounded. It is fucking stupid. If it doesn't make sense to some of you, just think of a sign at a restaurant that says free beer tomorrow. Then you're all juiced about free beer and you go there tomorrow and the same sign says free beer tomorrow. And then you go there the next day and it says free beer tomorrow. You never get free beer, right? That's exactly what taking down or making future videos is. It is absolutely, absolutely retarded as fuck to say that and think that. And only Matt Walker. He repeated this like the third time he said that. But anyways, after this hearing, because she didn't get what she wanted and to be able to take the videos down, she went the very next day and had her own favorite judge do it. And this time, Matt doesn't even introduce himself, but he's there at the end because she says, "Bye, both of you," blah, blah, blah. And then she tricks this judge into getting what she wants. She was like, "Oh, does it still include the taking down of the videos?" And the other judge was like, "Tee hee hee, let me see." So anyways.
What did you want to do with this one?
So, originally, when I filed my injunction, I have 2 minor children. They were listed on it. I came back today to have that amended. And Your Honor, one question, is the same requirement of not being allowed to post about me on social media included in this?
Let me double check. Let me go back.
Thank you.
So I've indicated defendant shall have no contact with plaintiff through any form of social media. Defendant is prohibited from posting any messages or content regarding the plaintiff via any social media platform.
Thank you. And Your Honor, one final question, when it comes to having the original documents sealed because of the information, is that something I would discuss today, or is that something I would talk to another department about?
Once it's dismissed, I'm not sure if it can be sealed once it's dismissed.
The people I spoke to originally, they thought that might be possible. I just didn't know if I needed to ask you.
Oh, it's possible. It's just illegal because if you look here on the last line, it says, after the hearing, the court may modify, quash, or continue the injunction after the contesting
today,
hearing.
But if it's not something that would typically happen here, I can definitely figure it out.
So you should file a motion. You can file a motion.
Okay.
With the court.
Hopefully that will make it invalid, because it is invalid because you have to wait till the hearing actually happens and then afterwards then do that. And it can't happen until the other person writes a letter contesting it and then gets a hearing on it, you dumb bitch.
To seal documents and for maybe a protected address.
Okay.
Those might be possibilities.
Okay. Thank you. Thank you.
So I'm looking at pulling up the other one. So I'm going to quash the other one. I did indicate on this hearing order that dismissed injunction is ordered sealed.
Oh, wonderful. Thank you.
Hopefully that will.
I appreciate it.
I would follow up to see.
I will.
If
I will.
was done. Let's see. Someone can tell me if I'm not supposed to do that.
Someone can tell me if I'm not supposed to do that? Fuck this bitch.
Thank you. Oh,
Great, thank you very much. All right, thank you.
Thank you both. I hope you have a good evening.
Oh, yeah. Thank you both with an L. Thank you both. Okay, so if the first one wasn't a conflict of interest, this one definitely was because he wasn't introduced. He stayed to the end, and she said you both, so we know he was there. Anyhow, the point is, this bitch is retarded, and she's a fat-ass liar. So it's another thing to, like, hear and be able to see video and then being able to diagnose video, being able to hear audio and diagnose it. But you can do the same thing with words and text. Now, let's bring it back to Matt Walker and his fucking retarded-ass notion of future videos, right? In the future, if you hear anybody say future videos, hopefully you think of Matt Walker's fucking retarded ass and then explain to whoever says that how retarded it is. You know what I mean? And so we can do that. We know now that when something is so fucking ludicrous, it's ridiculous, that it had to have come from Matt Walker. And if somebody else repeats it, they probably just haven't thought about it, and it's just the idea of dumbass Matt Walker. Now, this has already happened, so just like the future videos, in his petition to change Rule 122H, he says something that is so off the wall that it just can't be believed. He says that live streaming is being used as harassment, and not afterwards. He means during the court, when you're in court live streaming your own proceeding, that you are harassing people. That's what he says. Here's the document here. It says, pursuant to Rule 122, the Supreme Court permits recording in the courtroom. However, this rule has one paragraph in particular that has abused, if not openly weaponized, by people who are live streaming in court hearings to the internet to try to intimidate and harass others who are appearing to testify. Give me a fucking break. How? How do you do that? How do you live stream harassingly? It's just a recorded record of what's going on. You set your phone down and just let it do its thing. Like, Your Honor, excuse me, Your Honor, we have someone over here violently live streaming. What the fuck? Now, just as equally as stupid, you know how Shannon repeated that when Matt told her. Well, this judge basically repeats that because he heard it from Matt. This court finds that pursuant to 122, blah, 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 the use of a recording device in this hearing at this date could impact the parties' right to a fair trial, including the rights of the victim's privacy, the safety of the trial participants, and the possible disruption of the proceedings, because the defendant has shown in previous cases that his recording devices used to disrupt the proceedings and harass the victims, and that such harm outweighs the benefits of coverage. So this dude also thinks that setting your camera on the table and pressing a button can harass. He thinks it can harass the victims, and Matt thinks it can intimidate the witnesses. Give me a fucking break. So it's pretty obvious they use victims and witnesses to either shield themselves or sword themselves or arm themselves, right? That's all they have, right? They can't break the law or break their set of rules unless there's victims' rights or, protecting witness protection. It's the way they get an advantage, and it's dirty and slimy, and they're both pieces of shits, is what it is, and they're both criminals too.
Relationship started, or at least my case started, due to Mr. Myers contacting Miss Walker through the court case through Tucson City Court.
So he contacted her through the court. So there's a legal reason for contacting her, right? How do you contact somebody through a court? Maybe because of the court, but through it? Let me explain how dangerously scary that comment is, or what he said. The court started the cop's case. Not the cop started a case and then handed it all over to the court. The court started the cop's case. That's fucking insane.